Does technology, in terms of the advancement of technology, should it have any bearing whatsoever on the way we look at Roe v. Wade? For example, published reports most recently of a 21-week, that's 142 days, fetus alive and well now at 9 months of age with no apparent complications because the technology has advanced so far that we can now save children who are born prematurely at that level. Should that have any bearing as we look at the law?
The law has answered a different question. It's talked about the constitutional right of women in certain circumstances, and as I indicated, the issue becomes one of what's the state regulation in any particular circumstance.
But all I'm asking is, should it have any bearing?
I can't answer that in the abstract because the question, as it would come before me, wouldn't be in the way that you form it as a citizen. It would come to me as a judge in the context of some action that someone's taking, whether if it's the state, if it's a private citizen being controlled by the state, challenging that action. Those issues are...
But viability is a portion of a lot of that. And a lot of the decisions have been made based on viability. If we now have viability at 21 weeks, why would that not be something that should be considered as we look at the status of what can and cannot happen in terms of this right to privacy that's been granted under Roe v. Wade and Casey?
All I can say to you is what the court's done. And the standard that the court has applied, what factors it may or may not look at within a particular factual situation, can't be predicted in a way to say, yes, absolutely, that's going to be considered. No, this won't be considered.
All I'm asking is whether it should. Should viability, should technology at any time be considered as we discuss these very delicate issues that have such an impact on so many people? And your answer is you can't answer it.
I can't, because that's not a question that the court reaches out to answer.